Welcome, everyone. This is class number 16 of the Ibis Prep MBE crash course for the July 2024 bar exam. And this is one of my favorite presentations because this is a personal conquest for me, federal evidence. As you may or may not know, I've actually passed the MBE 4 separate occasions. And when I took it the first time, evidence was my worst subject. By the last time, it was one of my consistently best subjects. I learned how to master something that got the best of me, or I didn't do as well as I would have hoped the first time. And I think a lot of times in life, you'll find that great teachers are ones who had to learn this holy, precious, like a, a body of water that's pure, right? Like there's no infiltration from the outside that could poison the minds of the jury. We want to just present them with evidence that's fair for them to look at. So we have to look at it like that evidence just doesn't get admitted and then we'll take it out for whatever reason. It's like, we need to qualify evidence. Why would we let this thing in front of the jury? Well, let me ask you some questions. Is it relevant? Is its probative value not outweighed by its prejudicial value? Is it hearsay? Is it, is there some other reason why we should not believe in it? Why we don't find it reliable? Why we don't find it trustworthy and we don't want to put it in front of the jury? Once you look at evidence like that, I think you'll just start naturally getting a lot more questions right by like having trained yourself to be like, wait a minute, I don't think that the jury should see this. This is kind of prejudicial, or actually this kind of seems like hearsay. So let's kind of think about that, meditate on that, if you will, as we continue. So here's the approach to evidence questions. And this is my PowerPoint, so I can't blame anyone if you find it boring. This is my words. They're often very short, so you have time for a methodical approach. That's true. Evidence questions, you could fly through evidence questions. You might get them all wrong, but you can do them quickly. And I think that's a good point. I would just, bullhead my way through some of these subjects. Like, all right, I'm not good at it. Let me just do all the questions repetitively until I'm getting them all right. And somehow that would translate into me, like, I'm getting them right for a reason. I'm recognizing the patterns, like that'll translate. That's not the only thing you should do, but evidence is a way evidence is a subject you really can just like do the questions over and over and you'll start catching on to the tricks. So ask yourself, is it criminal versus civil, right? Orient yourself. What type of case is this? Because there are differences for admissibility in civil and criminal cases. Ask yourself, what stage in the case are we? Are we on direct? Are we on cross? Maybe is this a grand jury? Maybe this is a moment where the judge is just, preliminarily looking at evidence and its admissibility. Like, let's kind of orient ourselves by type of case and by stage in litigation. Who is testifying or trying to testify? Is it the defendant, a lay witness, or an expert, right? There's different rules that apply to different individuals who are testifying. If they are a lay witness, they can speak on things with personal knowledge. If they're an expert witness, they actually get to speak on, scientific or technical matters. So fourth, ask what type of evidence are you trying to introduce? Is it oral? Is it physical? Like, what is the actual evidence? Fifth, ask, is it relevant to the case? Does it make any fact in the case more or less likely? People struggle with accepting that that's the standard for admissibility of evidence. Does it have any tendency to make a controverted fact more or less likely? And if so, it's going to be considered relevant. Relevant just means that it's helpful in a little bit of a way. And then six, ask, is it hearsay or any exceptions? But we're saying don't jump to six automatically. So the reason why we say don't jump to six automatically is because people are just conditioned to look at hearsay. Like, oh, this looks like hearsay, let's not admit it. But like, hold up. Don't just jump to like a hearsay analysis. Look at every evidence question very methodically and be able to orient yourself, see what's going on, and then analyze the fact pattern. Okay, let's talk about relevance. So any piece of evidence has to be relevant in order for it to be considered for admission. So we're going to look at the 403 balancing test. Evidence is considered relevant if it has a tendency to make a fact of consequence more or less probable, than it would have been without the evidence, and it's material to the facts at stake. If the evidence is irrelevant, then it's not admissible. Like, it's not a common answer that this on the MBE, like it will be excluded because it's not relevant. But just because something's not a common answer doesn't mean you shouldn't understand it and be prepared to select it if it is the case. Like, if this is, Tommy versus Johnny's murder trial, and we're trying to bring in, evidence that Tommy watches I don't know, The Simpsons on Tuesdays, like, it's totally irrelevant. There's no reason that we're bringing this in. It's not going to any theory. It's just because we know the judge hates The Simpsons and we're trying to, like, that's not fair. It has to be related to the theory of murder, why he murdered, whatever it may have been. Relevant evidence can still be excluded if there's another statute or rule that mandates its exclusion, or if it does not pass the 403B balancing test, which states that the probative value of the evidence cannot be substantially outweighed by danger of unfair prejudice. So we should always know what the 403 balancing test is and memorize that, right? That the probative value of the evidence is not substantially outweighed by danger of unfair prejudice. That's the 403 balancing test. It's got to be relevant and it can't be overly prejudicial. The court may exclude relevant evidence if its probative value is substantially outweighed by danger of one of the more of the following. I would remember these because they could test any one of these: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. These are all reasons that relevant evidence could still be excluded if its probative value is substantially outweighed by one of those factors: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. Any questions? So, exclusion of relevant evidence. These are public policy concerns. I think that these are toss-ups on evidence questions. Like, you should probably get these ones right. That usually these things are not admissible to prove liability, but they are admissible for ownership or control. So let's talk about some of them. Liability insurance. Evidence of liability insurance is not admissible to prove fault or a party's ability to pay damages. Evidence of insurance is admissible to prove anything else: ownership, control, etc. So you can't bring in the fact that Tommy had liability insurance to show that, he did the crime. Subsequent remedial measures. Evidence of safety measures or repairs made after an injury is inadmissible to prove fault, defect, or inadequate warning. Remedial measures evidence is admissible to rebut a defense that there was no feasible precaution. So that question I've seen before, where it's like, there is a product that leads to injury, and now they want to bring in the evidence that it could have been designed another way, right? They can bring that in to show exactly that it could have been designed another way, not to show that in itself that means that it was faulty, but just to show that it was feasible to have been built with the precaution. So the other ones would be settlements, offers to settle, and plea bargaining. So in civil cases, compromises, offers to settle, or related statements are inadmissible to prove liability or fault, but that does not include statements made before the claim or threat of litigation was asserted. And then in criminal cases, pleas, offers to plea, and related statements are inadmissible to prove guilt. So we're typically going to exclude these settlements, offers to settle, and plea bargains as a matter of public policy. Why? Because we want to encourage people to, make offers to settle, to accept pleas, and do these things without the risk that it'll be used against them to prove liability or guilt. What's up, Robert? You're sharing jokes in the DMs, but not the whole chat. I see you laughing over there. Got eyes in the back of my head. Okay, character evidence. If nothing else, and Eric, yeah, I get it, RAC. You guys are class clowning together. That's good though. Just class clown. Now I feel like a teacher. Bring that note to the front, Robert. I want to read it to the class. Okay. If nothing else, civil versus criminal has different rules. So let's remember about character evidence. In civil, character evidence is not allowed unless character is at issue. What does that mean when character is at issue? Defamation, negligent entrustment, etc., or past sexual assault or child molestation by a defendant. In criminal, the prosecution can't bring in character evidence unless the defendant opens the door, places his character at issue, and then the prosecution can rebut with defendant or victim's character. So if they say, oh, you know, the victim was the aggressor and they open the door, then we could bring in a criminal case evidence to show that, nah, the victim was not the aggressor. Like, he's a peaceful guy, right? But you're not going to bring in character evidence in criminal cases unless they've opened the door. And in civil cases, it's just generally not allowed unless character's at issue. So what's an example? We're accusing Tommy of being a thief. I'm sorry. We're accusing Tommy of defamation because he called Johnny a thief. We're accusing Tommy of defamation for calling Johnny a thief. And now we want to bring in evidence of Johnny robbing a bank. Well, yes, we can bring that in because character's at issue. So we're trying to show that truth is a defense to defamation. This dude's actually a thief. He's out here robbing banks. Therefore, we didn't defame him. Same thing with negligent entrustment. Like, showing that this person was negligent is actually relevant because their character is at issue. Okay. This is a slide that's important. This tripped me up for a while. And Rob and I were actually studying together earlier. And he even said, this made me laugh, my wife would be so proud of me for getting this question right because it was a mimic question. And these are tough. These are real tough. So let's take a moment on this slide. So this mimic is a mnemonic that helps us understand exceptions to the general rule that we cannot bring in prior bad acts to show likelihood to or propensity to conform with that type of behavior. Fair enough? Like, that's the general rule. We cannot just say, you know, because Robert has been the class clown in other classes, he was the class clown in mine, right? It wouldn't be fair because then people don't get to escape their shadows, right? Like, we generally believe in a society of, you know, we can't prove that someone did something wrong currently because of things they did in the past. If that were the case, then you'd all be in a bad situation in life. You would never be forgiven. You're all a bunch of XYZs. No, you're all great people, whatever. I'm not trying to accuse people of anything. People are too sensitive these days anyway. About to get emails to Alexis saying I called you all a name I didn't even call you guys. But anyway, we live in a society and in evidence, we just don't want to use prior bad acts to prove that you acted in conformity today. That's just not fair. It's not a fair argument. However, there are exceptions. One is in sexual assault and child molestation cases, evidence of offenders' prior acts of sexual assault is always admissible. Good, right? We're not letting them off the hook with anything. And yeah, I think once a sexual assault, they're always, I don't know, I don't think anything, but maybe that's the thought behind that. Okay. However, there's a loophole that allows evidence of a person's past criminal or moral conduct if it helps prove an issue other than the defendant's tendency to behave like a criminal. So that's the concept. We're not going to bring it in to show propensity to conform with that behavior, but we will bring it in for anything else. Now, when they teach that in law school and they say anything else, you're like, well, what does that mean? Anything else? So on the bar exam, at least, they've helped us, you know, or some tutors or whoever came up with this mnemonic that helps us really understand what anything else could mean. It could mean motive, intent, mistake, or lack of mistake, identity, common scheme or plan. These are things: motive, intent, mistake or lack of mistake, identity, or common scheme or plan. The one that Rob was so happy that his wife would be so proud of him for was that it was a lack of mistake, right? It was that it was lack of mistake. Yeah, that they had done something one way before and now they're trying to say like, oh, you know, we made a mistake. And it's like, no, you've done this accounting, you know, this special accounting maneuver 7 times in the past. You can't say that you did it accidentally this time. Another one that's commonly tested is the red-nosed gun, right? Like, Tommy always robs the bank with the red-nosed gun. Well, now, can we bring in evidence of the Tommy having a red-nosed gun these 7 times to show that it was likely him that did it this time with the red-nosed gun? Yes, because it's identity. We're not trying to show that like he is likely to do it. We're just showing that he's likely to be the same identity. This is Mr. Red-Nosed Gun. You know, this is Rudolph the fucking serial killer, right? Like this is the gun he always uses. I think of identity as a good one of Batman, like Dark Knight, the Joker. Whenever he, you know, he always left his card with the Joker card. Like, okay, well, we got a fucking Joker card at the scene of the crime, Joker. You know, like we have all these other crime scenes where you left this card. We're gonna bring it in to show that, yeah, you know, substantively are probably the same person here. Another one is like they want to show that Susie always steals clothes from the store. And the way that she does it is by switching the tags in this like special manner. She does the old switcheroo. Can we bring in that evidence? Yes, because it's, you know, identity or common scheme or plan, something that like this is the way you always do it. It's likely that this is you who did it again. So hopefully you guys and girls and non-binaries and everything else, all people and aliens, can practice this and get these ones right. And you'll feel like Robert. It feels good to get this right and be like, you know what? This can come in. It's a prior bad act, but it's actually being brought in for motive, intent, mistake, identity, common scheme, or plan. Another one is like, can you bring in evidence that like Marvin Gaye and his dad got in an argument, and then the next day Marvin Gaye's father shot him? Well, yes, you can bring in the evidence of the argument the day before. Why? To show that it wasn't self-defense that the father shot him. It was a motive. He, you know, got in an argument, and that's what happened. I don't know if you guys know about that. Marvin Gaye's father shot him. It's kind of sad. His Father's Day's in the past. Now I can tell you the truth about relationships. Okay, so good stuff. We talked about character evidence. We talked about prior bad acts, the mimic rule. Now let's talk about impeachment. Impeachment is discrediting someone. You know, someone says something and we're trying to say that that's not solid, right? We're trying to impeach it. So you can impeach via contradiction, via prior inconsistent statement, bias or interest, a very common answer. So I'll do these two real quick: prior inconsistent statement and bias or interest. Here's a common scenario. We have a statement where Susie says the light was red. Now we want to bring in a statement, or Susie's testifying the light was red. We want to bring in a statement that where Susie said the light was yellow, like a out of court statement where Susie says the light was yellow. Can we bring that in to impeach her statement that the light was red? And can we bring it in substantively to show that the light was yellow? The answer is we can bring in only for impeachment purposes, right? Like we're not going to bring in a prior inconsistent statement for substantive purposes, because now we have two conflicting statements. Like this lady is just a straight liar. But how do we know, you know, once a liar, always a liar? That's what I told my friend today. But like, what can you bring it in for? You could bring it in for impeachment purposes. We can bring it in to impeach the statement and show that that's not a credible statement, that the light was red, but not to show that it was yellow. That's a good answer. I call that the red light, yellow light example. Bias or interest. This one comes up a lot. Like we can bring in evidence to show that Tommy was competing for priority in the gang, because that's would give him motive to lie about the, you know, other gang member. Or we could bring in evidence to show that like Susie was part of like the Mothers Against Drunk Driving, to show that she had bias against this dude who's like made the hit song Drinking and Driving is Fun, right? Like we can have these we can have evidence of people belonging to organizations or having affiliations that would show bias, that would cast doubt upon the credibility of their testimony. Sensory deficiencies. So Erica, she's not even here right now. The glasses, right? Like she was not wearing glasses at the time. Erica said, like right now, if Erica would just said I did something and then I was like, she wasn't wearing her glasses, she couldn't even see it. How would it be fair for her to say that I didn't do this or did that when she's a known blindy, right? Like, right? Like that's a sensory deficiency that you could bring in. reputation and or opinion for untruthfulness. So, you know, if you're in my Florida class, you recognize distinctions here, but you can bring in reputation and or opinion. Reputation, I have heard that. Opinion, I believe that. Truthfulness is always coming in. We had a question today that I did with a student. They were frustrated that this was the right answer. I told them they could bank on it, and it turned out to be the right answer. That there was an expert witness, and they wanted to bring in evidence that this expert witness had lied in a previous divorce proceeding that he was a part of. And the student was like, I don't think you can bring that in. Like, that's collateral. What does that have anything to do with this? And I said, it shows that they lie under oath, which is always relevant to credibility, right? They have a reputation for untruthfulness. This person is literally, we have evidence that in a proceeding, they went in front of the judge and said, I solemnly swear under oath, swore in the Bible, you know, and then they winked and then told a lie, right? So if you could do that then, why can't you do that now? Your propensity for truthfulness is always relevant when it comes to being on the stand. We're not going to put boys who cry wolf on the stand to tell us that there may be a wolf. Okay, so prior criminal conviction. So felonies are admissible if punishable by death or more than 1 year imprisonment. So it doesn't mean that they actually received the sentence, but that they were convicted of a felony that they could have been sentenced to over 1 year. And then misdemeanors are not admissible unless it involves dishonesty. And then crimes involving dishonesty are always admissible. Like, you know, you lied on your tax return or something like that, or I don't know, something that was just very dishonest, that would show, because it gets to that same point that, like, you know, we're always going to be concerned with whether or not this person tells the truth. So again, in life, you should always maintain a reputation for truthfulness.
Hey,
Yeah.
quick question. Back to your student who had the problem with the prior statement regarding lying on oath. Can you go over that one more time? Because I had a similar problem with that, and I got that wrong actually a couple times when I was doing my practice questions.
The truth of the matter is that if someone is testifying, even if they're an expert witness, we are concerned with their propensity to tell the truth, because by nature, they're on the stand talking to us, and we are a bunch of dumbasses if we're just going to sit here and let this person lie to us. So if we can bring in credible evidence that shows, that casts doubt on this person's propensity for truthfulness, then it's going to be admissible to impeach their statements. Like, if, you know, Tommy gets up here and says all these things, and then we want to bring in evidence that he lied in his divorce proceeding, it's going to be admissible. Why? To impeach the statements he made here, because and that's all impeachment really means. It doesn't mean to, like, white it out and act like it never happened. It's just to cast doubt, and then it's up to the, you know, the judge or jury to you know, to consider the weight of the evidence and to make a decision on it. But that's a way of impeaching. You can always impeach a testifying witness or someone on the stand based on, or their statements, you know, based on untruthfulness, because truthfulness is at issue. So that was that particular question, that the person was an expert witness, they were on the stand and they were talking about something, and we were impeaching them with evidence from an unrelated trial that they had lied under oath, because it is relevant, because, you know, that's the kind of takeaway, that truthfulness is relevant.
Okay, got it. Thank you.
No, of course, man. Okay, convictions over 10 years are subject to the inverse of the 403 balancing test, which means they're presumed inadmissible unless the probative value outweighs the prejudicial value. So do we understand what that means? Is that usually there's the argument that evidence won't come in unless its probative value is outweighed by its prejudicial value. And here, if the conviction's over 10 years, it's the opposite. We're saying that evidence will only come in if its probative value outweighs its prejudicial value. So not if it's outweighed by it, it won't come in. It will come if it is. So, like, that's also a distinction from Florida and other states, but just federal law today, that convictions over 10 years, they are presumed not to come in, but they can come in if, the judge determines that they are, there's a probative value to it that outweighs its prejudicial value. It kind of reminds me of an important point that people need to know, that questions of admissibility are for the judge and the weight of the evidence is for the jury. So if we have a piece of evidence and we're deciding whether it should be admitted or not, the best procedure is to have a hearing on that evidence in front of the judge without the jury present. So the judge could be the gatekeeper and decide, is this evidence that we should let in or not. Okay. All right. So let's talk about expert witnesses versus lay witnesses. So just in general, a lay witness is just a normal person, whereas an expert witness is actually qualified. Does anyone know the standard that we use to qualify expert witnesses at federal law today?
It's Daubert, but don't ask me the elements.
Yeah, Daubert. And it's the elements are just that they have generalized, specialized knowledge in their field, and it's based on whether they've published articles or different things. It's not like a gatekeeping community like Fry is. It's more of just, a case-by-case basis if they have the helpful, qualified, reasonable certainty standards. So a lay witness, unlike an expert witness, a lay witness does not need to be qualified in any area to testify in court. A lay witness, like any other witness, must limit testimony to matters which they have personal knowledge about. So that's the key to a lay witness, is it has to be personal knowledge. Well, a lay witness can become familiar with someone's voice for the purpose of trial, but cannot become familiar with someone's handwriting for the purpose of trial. So that's a testable point right there, that a lay witness can become familiar with someone's voice for the purpose of trial, but they cannot become familiar with someone's handwriting for the purpose of trial. So you'll get that question, like, it's a lay witness and they get familiar with someone's handwriting. Can now they be brought in to authenticate the handwriting? The answer is no. But if it's the opposite, it's someone's voice and they become familiar with their voice over the trial, the lay witness can authenticate it. Now, someone who was familiar with the person's handwriting before the trial can be used to authenticate it, like a bank teller, let's say, who always sees the way you write. That person could come in, but just know that a lay witness cannot become familiar with someone's handwriting for the purpose of trial, but they can with their voice. And what can a lay witness testify about? Things they have personal knowledge of. So an expert witness, in order to be admissible, an expert witness must practice in a profession relevant to the issue of the case, be skilled in their particular profession, have specialized knowledge through training, education, or practical experience. Their testimony must be helpful. They must be qualified. They must have reasonable certainty and proper factual basis for their testimony and rely upon reliable principles. Experts may render an opinion on an ultimate legal issue, but experts cannot give opinion on D's mental state in a criminal trial if it's an element of a crime or defense. So they can't say, I think he intended to kill Tommy, or like, I think that he was you can't say that he had the mental requirement, the mens rea, to satisfy an event. You could say, like, I think that he was having, schizophrenic episodes, but you can't say, I don't think that he had the required mindset to formulate intent for, you know what I mean? Like, they can't give opinions about elements of the crime or defense. They could just give opinions about their things that they've observed and things that they're specially and technically qualified to do. So again, the standard at federal law is Daubert, and Daubert is more of a case-by-case analysis where the judge is the gatekeeper instead of like the traditional Fry analysis. Okay, testimonial privileges, and this is very heavily tested. The difference between spousal testimonial privilege and marital communications privilege. So spousal testimonial privilege is that the spouse can decide not to testify against the other spouse, but they love to trick you like Tommy and Susie are married. Susie wants to testify against Tommy, but Tommy wants to prevent her from testifying. That's not possible. Under the testimonial privilege, the testifying spouse can refuse to testify. The other spouse cannot prevent them from testifying. So if Susie hates Tommy, then Susie can easily testify against Tommy. Whereas the marital communications is even more robust. Tommy could prevent Susie from testifying about a marital communication. A marital communication, if you remember Barbara's album, Pillow Talk, that was, how I taught marital communication. Things that are spoken within the sanctity of marriage, things that you wouldn't say to someone unless, they were your partner that you truly trusted. That's a marital communications privilege. That survives, the marriage and death. Whereas a spousal testimonial privilege only lasts for the duration of the marriage. And like I said, it can only be invoked by the testifying spouse. It can't be invoked by the other spouse to prevent them from testifying. So the attorney-client privilege, it's important. It's very important in law that what clients and attorneys say to each other is in secrecy and privileged, but it doesn't apply to crimes or fraud, right? So like if the attorney, you gave the attorney, the client was talking to the attorney about perpetrating a crime or committing a fraud, then it wouldn't be privileged. And another part of this that they love to test is the subsequent litigation between former co-parties. So if Tommy and Johnny are parties and they're suing Susie and they say a bunch of stuff to their lawyer, Bradley, right? And then later, Tommy and Johnny get in a fight. And now Tommy wants to use some of the information that was revealed when Tommy and Johnny spoke to attorney Bradley against that party. Can they do it? The answer is yes, because there's no privilege when both parties were there. So both parties were there and the attorney, and now they're going to be against each other in subsequent litigation. Those communications are not privileged in that regard. So hopefully that's helpful. At federal law, they recognize a psychotherapist, social worker, patient privilege, but there's no federal recognition of the doctor-patient privilege. So we had a tough question today that was like a mix of evidence civ pro, like brutal, right? And the question asked, in a federal civil rights case between A and B, Tommy wants to invoke the doctor-patient privilege. Should they use the state or federal law, and should the privilege be denied or granted? And the answer there was they should use federal because it's actually a civil rights issue. So you're not even going to do an Erie analysis. You'll just use federal law. And the answer is they should deny the privilege because the doctor-patient privilege is not recognized at federal law. Now, another way that question could be asked was Tommy and Johnny are against each other in a diversity case. What should they use, state or federal privilege law? The answer is state privilege law. Privilege is considered substantive for Erie purposes, right? So they can mix together these civ pro and evidence. They can mix together these civ pro and evidence questions. So to reiterate, if you have a question that's asking about privilege, if it's a diversity case, privilege is a state issue. If it's a federal question case, privilege is a federal issue. And remember, the federal MBE world does not recognize the doctor-patient privilege. There's no privilege between doctors and patients. And then the spousal testimonial between marital communications. Marital communications is the pillow talk privilege. Communications that are said between spouses in the sanctity of marriage are protected. Either spouse can invoke that. And then the spousal testimonial privilege allows for the spouse to refuse to testify against the other spouse but it cannot be used by the spouse to prevent the other spouse from testifying if they so choose. Any questions on the testimonial privileges, attorney-client privileges, marital communication privileges? Cool. Okay, so judicial notice, think date on a calendar, like Saturday, holiday, weather on a certain day. What can be subject to judicial notice? Facts that are generally known and easily determinable by accurate source. And then this, they test a lot. And I swear, I told people, I was like, they're guaranteed to test this. They test it every year. And then I asked people last time, did they test it? And everyone said, no, they didn't. So it's like, you know, they have a huge Q bank. They don't always test anything. That's why you got to know everything, in my opinion. But this is tested a lot, which is in civil, it's a must, right? They must accept the fact as conclusive, and they must take judicial notice. Whereas in criminal case, we have a must may, right? Like they must take judicial notice of it, but they may or may not accept it as conclusive. So in criminal cases, we're not going to take presumptions. There's no presumptions in criminal cases. You have to prove everything. So for judicial notice, for a criminal case, you know, they must take judicial notice and they may accept it as conclusive. If it's a civil case, they must take judicial notice and they must accept it as conclusive. So just remember that. If you learn one thing, that's my little thing for tonight. If you learn one thing, civil cases is the must for judicial notice, and criminal cases is the must may for judicial notice. So there's a question I got today that said, in a criminal case, Tommy is, you know, on trial, and they asked the court to take notice that if you go from Chicago to St. Louis, you have to cross state boundaries. And the answer is the court may, but is not required to take judicial notice of this presumption, right? Like, yeah, it's very obvious. You do have to cross. There's no good argument against it, but still, they don't have to accept it, right? They could say like, oh, well, maybe you could get there some other way. Like, you know what I'm saying? It's just in criminal cases, we're not going to take presumptions. Here's another one that they love to test. And I have to explain it in this way, and it might hurt some people if this is your real life situation. I'm sorry, preemptively. But you can't presume in a murder trial that someone's dead. You have to show me the body, right? So Tommy's been missing for 15 years, and Susie is trying to, you know, take the presumption in the case that Tommy's dead. Can they do that? The answer is no. They haven't proved that she's dead, that he's dead. Why? Because Tommy may very well faked his death, went to Tijuana, and is living with someone that doesn't nag him all the time, right? Like that happens. So you can't just assume that because someone's missing for a certain number of years that they are indeed dead. In a criminal case, we have to prove these elements. Okay, this brings us to hearsay. Perfect timing. Hearsay is tough, and if you fell asleep for the first, you know, 80% of class, try to lock in for this last part, because I really want to teach hearsay, and I think this will help. So hearsay is an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. Hearsay is generally admissible, subject to several exceptions and exemptions. So in federal law, there are exceptions and exemptions. A statement is an oral or written assertion or nonverbal conduct intended as an assertion. There's no such thing as machine or animal hearsay. Easy question to get right. No, it's not hearsay. The dog barking is not hearsay. The radar gun saying 50 miles an hour is not hearsay. Exemptions versus exceptions. So we also have what's called non-hearsay, things that are just not hearsay. What's not hearsay? Anything that's not brought in to prove the truth of the matter asserted. So an example of that is like the statement that Tommy stole the TV. Not to show that Tommy stole the TV, but to show that the person who made the statement knew who Tommy was and knew that there was a TV. They had notice of this person. Andrew fired the gun. Jenny said that Andrew fired the gun. Why? To show that Jenny could speak. She wasn't a mute, right? To show that Jenny was aware that Andrew was a person, was aware that there was a gun, like certain things, just anything else but to prove that Andrew fired the gun. If we're bringing in to show that Andrew fired the gun, then no, it's inadmissible hearsay. I mean, unless it's an exception. But if it's being brought in for anything other than to prove the truth of the matter asserted, and the matter asserted is what the statement is actually saying, then it's not hearsay. Hearsay is when it's being proffered to prove the truth of the matter asserted. Okay, so now if we have a statement and it looks like hearsay, like we're bringing the statement in, to show what it's saying. He hit me, to show that he hit me. We're gonna only let that in if it's an exemption or an exception. In practical senses, there's not really a difference. Like they're just both admitted. But on the MBE, you do need to know the difference between exemptions and exceptions because the subtlety will help you get answers right. Okay, let's start with this non-hearsay slide. So common non-hearsay uses of out-of-court statements. The following statements are not hearsay because they're offered for purposes other than the truth of what they assert. Statements of independent legal significance, statements containing legally operative words or phrases, such that the statement itself is a legal factor in the case. Common with defamations, contract cases, and adverse possession. In a contract dispute, A testifies that B told him it was a done deal. Like that statement, it was a done deal, has an operative significance in its own. Statements offered to show their effect on the listener. In a comparative negligence claim, a statement by a third party warning the plaintiff of the injury causing condition, right? Not to show that they were negligent, but to show that, they knew about it. Statements offered to show their knowledge, again, charged with conspiracy, claims he did not know about the crime. An out-of-court statement indicating D had been told about the specifics of the crime would be admissible, indicating he knew it was being planned, right? The knowledge of the ownership, the knowledge of the thing at hand. And then statements offered to show state of mind. A statement by the defendant before committing a crime indicating he might have been insane. So all these things are just not hearsay. They're not being brought in to show that they, to prove the truth of the matter asserted, but they're being brought in for these other reasons. Independent legal significance, to show the effect on the listener, the speaker's knowledge, or the state of mind. I wouldn't say this is tested as much, but just kind of know that not all statements are hearsay. They have to be brought in to prove the truth of the matter asserted. Then we have hearsay exemptions. I think an easy way, one way to look at exemptions versus exceptions is, and we'll go over this slide. And I'm sorry, I got like 10, 15 minutes left. So just kind of lock in with me. Is that exemptions are a party opponent admission is an exemption, whereas a statement against interest is an exception. They have the same effect. The evidence will come in, but just try to remember them. And then statement against interest, we need the declarant to be unavailable. So statements against interest and party opponent admissions seem a lot to be very similar, but the distinctions are party opponent admissions, availability is immaterial, and party opponent admissions are actually deemed exemptions. Statement against interest, unavailability is required, and a statement against interest is actually an exception, not an exemption. Most of them are exceptions. These are the list of exemptions. So an admission, and this is tested a lot, and I'll go over this more, an out-of-court statement by a party is admissible if offered against that party. Judicial admissions made in a pleading or testimony. Adaptive admissions, that's the acquiescence of another statement. Silence could be an admission if the parties heard, understood, and was capable of responding to a statement, and a reasonable person in the party's position would have responded. Vicarious admissions are made by an agent or employee, so look for that, like the agent or employee makes an admission, that one's tested a lot. And then co-conspirator admissions. Statement made by defendant's co-conspirators are admissible against the defendant if in furtherance of the conspiracy. Prior inconsistent statements given under oath. So if it's given under oath and it's inconsistent, we could bring it in as a hearsay exemption. And if it's a prior consistent statement, it doesn't need to be under oath, but it could be brought to rebut a charge of fabrication, improper bias, or improper motive. So for impeachment purposes. And then a prior statement of identification after perception. The red Honda just hit me and fled the scene. We had a question today where it's like, could this be brought in as a recorded recollection or a statement of identification? The answer was both, because they forgot what they said, but it was reliable. So it was recorded recollection, and it was a identification. They said like, Tommy with this license plate just left, or maybe it was a present sense impression even. I think it was. Regardless, there's like certain times where a statement can qualify as, for certain reasons, for multiple reasons. So just know that these are the exemptions: admissions, inconsistent statement given under oath, prior consistent statement, and then prior statement of identification after perception. So remember the categories: non-hearsay, exemptions. The main type of non-hearsay, I would say, is to show effect on listener. The main type of hearsay exemption, I would say, is the party opponent admission. Now we get into, oh, here's a party opponent admission. A statement offered against a party that was made by a party or representative of a party, statement which the party adopted, statement by a person authorized by a party to make statement on subject, statement by party's agent or servant concerning matter within the scope of agency employee made during existence of the relationship, or a statement was made by a co-conspirator of a party during the course and in the furtherance of a conspiracy. Really look out for these party opponent admissions. They come up a lot. Now here's the list of exceptions. And again, remember there's two categories: where unavailability is required and where unavailability is immaterial. Where unavailability is required, former testimony exception, statements against interest, dying declarations, statements of personal family history, statements offered against party procuring declarant's unavailability. And then the rest of them are, doesn't matter if they're unavailable or not. Unavailable means that they're not there to testify. They're dead or in a coma or out of the country or something like that, or they have no memory of the time. So present state of mind, excited utterances, present sense impressions, physical conditions for medical diagnosis or treatment, past recollection recorded, business records, public records or reports, judgments and prior convictions, ancient documents, documents affecting property interests, learned treatises, family records, and market reports. You should have this kind of list memorized because any of them can be tested. I'm going to go into some of them more deeply. So statement against interest, remember this, if you go back to the chart, statement against interest, unavailability is required. So a statement against, hearsay statement is admissible if at the time it was made, it was against the pecuniary or legal interest of the declarant. The requirements, the main one is the declarant is currently unavailable. 2, the statement was contrary to the declarant's pecuniary proprietary or penal interest when made. And 3, a reasonable person would not have made a statement unless he believed it to be true. So I'm going to read this next point. I've talked about it a lot, but hopefully this registers with everyone on this wonderful Tuesday evening. What's the distinction between a party opponent admission and a statement against interest? A party opponent admission is a statement of a party or vicarious statement attributable to that party. There's no requirement that the statement is against the declarant's interest. A statement against interest is any statement against the declarant's interest at the time it was made, and there's no requirement that the declarant is a party to the proceeding. So party opponent admissions are parties to the proceeding, and they don't have to be unavailable. Statement against interest, they don't have to be parties to proceeding. They could be, but they don't have to, but they must be unavailable. Those are the key differences between party opponent admission, statement against interest. Dying declaration, important to note, only available in civil cases and homicide cases. We're not going to bring a dying declaration in a criminal case that's not homicide, burglary or arson or something like that. Dying declaration, we had a question today where the student was compelled to pick the wrong answer, and I helped him pick the right answer, or her, or whoever it may have been, because they said shortly before death, Aunt Martha said what she wanted. And I was like, shortly before death is not a dying declaration. Sorry for baby Erica to hear about this morose topic, but shortly before death is not a dying declaration. A dying declaration has to be made while you're under the belief of impending death. So hearsay statement is admissible in civil cases or homicide cases if the declarant made the statement under the belief of impending death and the statement describes the cause or circumstance of the impending death. What are the requirements? The declarant is currently unavailable. The out-of-court statement was made under the belief of impending death, and the statement was made regarding the cause of circumstances regarding the belief of impending death. So death of declarant is not required. They have to be unavailable, but they don't have to be dead. They could be in a coma, they could be out of the country, just has to be a dying declaration. The declarant must only have believed he was dying at the time the statement was made. You don't have to actually die. It can't be like you're about to die and you say, Tommy didn't sign that contract with the intent. Like, you can't make some crazy statement or like, I want my will to go to Charlie. No, it has to be like, oh my God, Tommy shot me. Like something like that. Like, a dying declaration. I challenge everyone out there to think about what your last words will be so that, you're prepared. I believe in over preparation. I think Louis XIII had the best, right? He said, why do you weep for me? Did you think I was immortal? I just feel like I don't know if he really said that, but that's the legend. I've been thinking about what I'm going to say. I think I got some time, hopefully. Okay, so statement of physical condition for diagnosis or treatment. This is another one, but this one, unavailability is not required. So I went over two where unavailability was required. Remember that. Statement against interest and dying declarations, we need them to be unavailable. This one, they don't have to, they could be available. So hearsay statements made to medical personnel for the purpose of diagnosis or treatment may be admissible. The requirements of the statements must be made to medical personnel. Medical personnel or anyone involved in treatment or diagnosis, not necessarily a doctor. And the statement must be pertinent to assisting in diagnosis or treatment of the condition. Related statements about an injury-causing event are usually inadmissible. If it's like, you know, Tommy shot me and then robbed my chain, well, robbing the chain, that statement would not be admissible. The statement would be bifurcated and we'd only allow the statement about, you know, medical diagnosis. For example, a statement made by declaring to an emergency doctor that he was shot will be admissible, but the identity of the shooter will not, as it's not pertinent to the treatment. Include statements of past conditions as long as the statement is made for the purpose of diagnosis or treatment. So a key distinction here is the doctor, the medical person, doesn't actually have to be the one who treats you. They could just be someone you go to, and then you end up going to, you know, Dr. Miami and doing something else. Okay. My neighbor's daughter, the TikTok girl for Dr. Miami, Safwan knows her. All right, business record exception. So requirements. Hearsay statements in the form of business records are admissible if they are a record of transaction made or recorded by a business, transaction reports patient records, made in the regular course of business, made at or near the time of the matters described, made by an employee with personal knowledge of the facts recorded, and authenticated or certified in writing. Police reports in criminal cases, police reports or other criminal investigator reports are inadmissible as business records or public reports. Okay, so we did this one. We talked about this the other day, and I think people were frustrated by it, by the business records exception. It came up in CivPro, but it's really evidence. I think you can all see that CivPro and evidence do bleed together in a lot of respects. But the concept was, we have this scenario where there's a fire. As soon as the insurance company hears the fire, they anticipate litigation. Then they send someone out there to document the fire. And people said, oh, well, those pictures are business records. They're admissible. Those are inadmissible, or they're privileged because they were made in anticipation of litigation. That's the rule about the business records, is that business records that are made in the regular, ordinary course of business are going to be admissible as non-hearsay. But if they're made in anticipation of litigation, then they will be privileged and protected. Some miscellaneous hearsay exceptions. So these are, again, where unavailability is immaterial. They could be unavailable or available. Learned treatises. So learned treatises arise with expert testimony only. Learned treatises are accepted authorities in a given field. They're established as reliable and accepted authority by testimony, admission, or judicial notice. Experts can rely on learned treatises on direct or can be impeached with information from learned treatises on cross. And if admissible, statements from learned treatises may be read into evidence only, right? We're not going to bring in the entire book. We're just going to read into the relevant statement. Family records, statements of fact found in family keepsakes, jewelry engravings, genealogies, and then excited utterance. I'll give you a key, like, you know, I'm not saying always pick this is always the answer, but it's a good, you know, rule of thumb, is that excited utterances end in exclamation points. That's just kind of the grammatical way of showing I'm excited, right? Like exclamation point. In Spanish, they'll put the exclamation point even beforehand, but like excited utterances typically end in exclamation points. It has to be immediately after. It can't be 10 minutes later. You said, wow, that was crazy. It has to be like, oh my God, that's crazy. Like in the moment. So relates to a startling or exciting event or condition, was made while the declarant was under the stress or excitement of the event, and the declarant's emotional state is key. Declarant must be under such excitement or stress that one would not normally have an opportunity to fabricate the statement. I like that last sentence because it kind of helps us understand, why are we letting all these exceptions in? Because these are reliable. It's reliable that someone would make an admission, a party opponent. It's reliable that someone make a statement against interest. It's reliable that someone, as they're dying, wouldn't say something, you know, that's not reliable. It's reliable that someone's gonna, oh my God, he shot me. They're not gonna say something unreliable in that moment. That's why these exceptions come in, because, you know, out of court statements, he said, she says, man, go on Reddit. People say bad things about me sometimes. How can you say anything bad about me? It's not reliable. But like, if you you know, if someone said as they were dying, Andrew sucked, like that would probably be reliable. If it was that deeply in their heart, maybe it would be a reliable statement. So it's kind of that whole concept of like hearsay statements are generally unreliable because they're not subject to cross. They're not, no one was there. How do we know why they said it, what their motives were, whatever. But these exceptions are going to be allowable or admissible is a better term because there's reason to believe that it wouldn't be fabricated, right? They're not normally situations where they'd have an opportunity to fabricate. All right, a recorded recollection, just a couple more and we'll be done, I promise you. I just want everyone to pass this test, you know? So recorded recollection versus refreshed memory on stand. I think it's good to be able to differentiate party opponent admission from a statement against interest based on availability of the declarant, and differentiate recorded recollection versus refreshed memory on stand. Remember, refreshing a memory on stand is just like the witness is on stand, they can't remember what they're going to say. And so you give them something and they, hey, buddy, read this. They read it and then they say what they're supposed to say. You refresh their memory. Even a bowl of spaghetti can be used to refresh someone's memory on the stand. Whereas a recorded recollection is actually going to be admitted into evidence. This is an exception where a recorded statement based on personal knowledge and made or adopted by the witness while the matter was still fresh in his or her mind is not barred by the hearsay rule if the witness no longer has sufficient recollection of the matter to fully and accurately testify again about it. So the key to recorded recollection is that it was accurate at the time it was made, but the declarant no longer has any memory of it. That's why, you know, recorded recollections could actually come in. Whereas refreshing memory on stand is just like, hey, Tommy, look at this. Oh yeah, Johnny did it, right? It's just something that's used on to refresh their memory on the stand. Like I said earlier, preliminary questions concerning the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court, subject to the provisions subdivision B. In making its determination, it's not bound by the rule of evidence except those with respect to privileges. The weight of evidence is decided by the jury. So times where we're not bound by the rules of evidence would be preliminary questions for the judge. Like the judge is allowed to consider hearsay, the judge can consider anything. And then grand jury proceedings. Grand jury proceedings, the rules of evidence do not apply. Perfect. I was like, how many more slides do I have? But after that, we just do cram guide details and we'll go over these. As you know, the cram guides are the most amazing thing to just cram the important details. But I do want to say evidence is a subject that you can go from 0 to hero in because the questions are not super convoluted like Civ Pro and property and con law. They're quick and easy. I used to say they're like scorpions. They're really tiny, but they can be super hard. And, you know, you just want to practice and practice and practice them. So I really appreciate everyone sticking out with me tonight. Go Panthers. And thank you all so much for joining me. I'm going to stop this recording.